All right, it's 1:30 and we're going to start promptly because we got a lot of questions submitted in advance. So hello everybody, this is Eric Hauge. I'm Executive Director of Homeline. And today you are joining us on, oh boy, I put the wrong date. Wednesday, August 26th is the correct date. Wednesday, August 26th, and at 1:30 for another one of Homeline's weekly webinar series where we're discussing tenant-landlord legal issues during the COVID-19 pandemic. And again, we thank you for joining us today, the 26th of August. Just a reminder of what Homeline is. We are a statewide nonprofit organization, and our main program is a free and confidential legal hotline that any tenant in the state can call and get free and confidential legal advice about their specific situation. And we've been around since 1992 and advised over 250,000 renter households. And we advise folks in English, Spanish, Somali, and Hmong languages. And later on some of the slides, there'll be information about how to contact our tenant hotline if you do have questions as a renter. Just a couple more introductory things before I have Homeline's Managing Attorney and Hotline Director Mike Vraw introduce our guest speaker for the day. Just a reminder that we have been doing, Homeline's been doing these webinars on COVID-19 related issues since about mid-April. And most of them are recorded and available on our website. You see the bottom here, there's a section of our website, if you go to homelinemn.org, where we have a COVID sort of drop-down menu, and you can sign up for next week's webinar, few previous recordings of webinars, and we have a number of frequently asked questions and legal memos and general information about tenant-landlord law issues in Minnesota during the pandemic available on the website. Including registration for next week, where we have another special guest speaker. We're going to be joined by Assistant Attorney General Catherine Kelly, and she is in the office of Keith Ellison, the Minnesota Attorney General's office, and is leading on some of the work, on all of the work that the Attorney General's office is working on in terms of enforcement of the executive order on evictions and lease terminations. So she'll be sharing a little bit about their perspective on how they're enforcing it and issues related to that, and also answering questions. Just like today, where we do encourage folks to submit questions in advance, and we'll get to those first. And then if you do have questions or comments throughout the event today, you're welcome to submit them via the Q&A Zoom tool or over the chat system, and we'll try to get to them as we can. One last thing I wanted to share before we get started, because it just got announced this week, is that this was initially announced back in July, that the governor had taken about $100 million of federal CARES Act money that came from Congress. There was a large portion that the state got for a number of reasons, but Governor Walz decided to take $100 million of it and put it towards the Minnesota Housing Finance Agency, housing department of the state, to go towards a COVID-19 housing assistance program that has officially launched as of this week. So if you are a tenant or a homeowner who is facing housing instability due to the pandemic, and you need assistance for rental payments or mortgage payments, you can now apply through this program. It kicked off on Monday, and the information about how to apply is right there. Probably your easiest way is to call 211 or visit 211unitedway.org to sign up. So that's a good tool, a good resource that renters can use to access housing subsidies, housing stability funding for rent payments. And we encourage folks that are on this call, if you're service providers or tenants or landlords, please let folks know about this program and that it's available right now. So with that, I'm going to pass it over to Homeline's Managing Attorney and Hotline Director Mike Vraw to kick off, to introduce our speaker and kick off today's webinar.
Thanks, Eric, and good to have you back after a couple weeks driving an RV across the northern part of Michigan. We are excited today to have special guest. As I've mentioned before, those of you that have watched these sessions before, I've been doing landlord-tenant law since 1996, working with Homeline. But our guest today, attorney William Dane, who works at the U of M and Minneapolis Student Legal Services. I looked at what you wrote down here, Bill. You've been there for 35 years. Is that right? 1985. Is that when you started?
That's correct, but that wasn't my first job. I came out of law school and worked for legal aid, doing housing law for 3 years prior to that. So I've had a lot of time in the housing law business.
But at the Student Legal Services since 1985, is that right?
Yeah, that's right.
1985, of course, for those of you that remember, that was the year that New Coke was launched. An important year. But Bill, I'm going to let you talk a little bit about what you do currently, which is pretty much the things we see on the page. And then you prepared sort of the anticipated topics that you think students should be asking about right now because you're getting these questions now. And after that, we'll go through the questions that are being submitted either in advance or as we're talking.
Sounds good. And we actually will likely address some of the questions as we're going through the outline a little bit too. But yes, Mike's right. I work at University Student Legal Service on the campus of University of Minnesota, Twin Cities. We're located over on the West Bank in the West Bank Skyway. Our eligibility for our service is determined by payment of the student service fees. So any student who pays that as part of their registration is eligible for our service, along with a host of other things. There's some controversy, of course, because students aren't coming back to campus in the same numbers that they were anticipating or were hoping. And so the question is, should you still pay your student service fee? For our office, the answer is still a pretty good value because our intakes are up 22% at this point this year over last year, mostly due to COVID. So it's probably a good idea. People can reach us. The number's right on the screen, and also at our email address. We do a lot of things besides landlord-tenant law. Landlord-tenant law is our #1 area of concern right now, with over 50% of our cases involve that, but students contact us about any number of things. A lot of international students have immigration issues. We do criminal misdemeanor, which is always important on a college campus. Tons of consumer matters. Students buy bad cars, bad computers, things like that. We also do public benefits, so it takes us into some of the other COVID things like unemployment benefits. Again, most of our services are free if you pay the student service fee. My level of experience is on there as well. Am I able to advance the slides, or I'm not sure how we do that? Okay.
Yeah, just let me know, Bill.
Okay. COVID-19 concerns for student housing. Just by way of background, of course, we all know pretty much what's happened here. But in terms of university students at the University of Minnesota and a lot of other campuses around Minnesota, it was about March 16th that the University of Minnesota closed its campuses in response to health and safety concerns about COVID. And then right away after that, Governor Walz used emergency powers to issue stay-at-home and shelter-in-place orders that affected a lot of students. And then there were a lot of college students all over the state of Minnesota who found it more than practical to simply move from their campus, hopefully back to their home, because that was the easiest move, but others were moving, some of them were moving off of campuses and into housing near university areas. And some of that housing was being vacated by people whose own COVID concerns caused them to want to move along. Next slide, I think. Okay, so the immediate response by students when those orders went out, again, many moved home with their families, and that immediately raised a lot of tough questions for students and families. We're no longer living in a place that we signed a lease for. as a student, what do we do? And sometimes the answer wasn't as simple as asking for help from home, because a lot of the guarantors on leases that we were seeing were parents who, many of whom had lost jobs or lost significant hours at their jobs, and therefore the family budget had tightened to the point where they couldn't simply work out a way to simply write another check for a place that no one was living. A lot of international students left the country from the U of M campus, and I'm assuming that happened at campuses all over the country. They were leaving for numerous reasons, but mostly because the campuses were closed. And in many, many instances, their governments were telling them to come home because the situation was so uncertain. They just felt like it's better to have our nationals here rather than all over the United States, not quite clear what's going to happen. We know of at least one government that sent a charter to Minneapolis, St. Paul, and all of the students were told, I think they only had a very short notice, like something like 48 hours. Pack your things and be on that plane, and you're all coming home. And it was a pretty full plane. So a lot of housing units got vacated at that point by those students. And of course, for those students, the idea of returning home and paying rent became a very big struggle as well. And then there were a lot of students who were in leases that are very near the campus for buildings there. And many of those students just found it extremely difficult to live near the campus because they really had to restrict their activities, and a lot of things closed. Many businesses closed in response to the governor's order, and it was nothing like normal campus life. So a lot of those students felt it was best to move away from the campus area as well. Next slide. Okay. Now, the response by landlords varied because, landlords run across a spectrum of some very small landlords who own one or two properties to landlords who are multinational, not too many multinational, but several near the University of Minnesota are multi-state landlords. There are some that have places in the US and Canada. But most of them really felt it necessary to do things to protect their employees. So they would shut down common areas and get rid of a lot of the other amenities, restrict access to management personnel. Many of them were cutting back on their staff and curtailing access to buildings. And so it became very difficult in some aspects for students to live in these buildings. Going into a large tower, like around the campus, you see places like Wahoo, which is probably our biggest building that people live in on the East Bank. Going into that building at night, if there's no security personnel or no people to greet you at the front desk, that's a pretty intimidating thing. And many students have to be out and doing things in the evenings and late into the evenings. So that became very much an issue for a lot of students in terms of their feeling safe and the way that they responded.
And Bill, let me jump in with a quick clarification here. You're talking about non-dorm situations, right? When somebody hears big building by the U of M campus, they might think, is this a dorm that you're talking about?
Yeah, the dorms were a little bit different situation, but in the dorms, the university emptied the dorms, essentially, sort of by fiat. They said everybody's moving out, and then they consolidated the small number of students who had no place else to go in a couple of different dorm areas so that they could offer as much of a full range of service to those people as they could, but still maintaining some level of social distancing. So,
but you're talking private market landlords is what we're really talking about right now.
Private market landlords that we're really talking about here.
Yep. Okay.
And I'm guessing that the response by universities around the state, universities and colleges, were quite different. I'm sure that some of them felt like the way that they had their dorms and things set up, that they could isolate on their campus a lot better than the University of Minnesota felt it could isolate people. So I'm sure that there were a range of responses to that in the dorms around the universities and colleges of the state of Minnesota. But at the University of Minnesota, it was a concerted effort to empty the dorms. And I did not learn until much later that many of these students who left the dorms actually went into housing near campus and were filling spaces vacated by some of the other students who didn't feel safe there anymore. So, see, I think that Scott Career had clarification. Housing on campus was open in the spring. Consolidation did not happen. We offered all students who moved out credits for housing. Okay, well, Scott would know because he's the person responsible for that at the university. I know what I knew from what the press reported, and that there was some consolidation, and some dorms actually closed, but apparently that did not happen. And there were refunds at the University of Minnesota. I don't know if there were at other places. Let's see. Yeah, communication became a little bit difficult because landlords primarily corresponded with tenants through texts and emails and face-to-face meetings, which had been really a common mode of communicating with your landlord, even in the biggest buildings, that it was common, but that became a little too risky. So things got a lot more impersonal. You couldn't just stop in and talk to that person in the office who kind of knew you. Now you had to send an email, and that really impacted, I think, some of the communication. Some of the landlords, many of them, I would say, came up with standard responses to student concerns. It wasn't unusual for us to see students with form letters that were basically acknowledging that, you know, these were difficult times, and then committing to varying degrees of assistance or action. And but one thing was very consistent, and that was most landlords were reluctant to release students from leases. And I think that was for fear it would create an onslaught of similar requests. So landlords were really having a, excuse me, difficult time trying to figure out what the extent of the problem would be. And so if they knew when the first dozen people asked to be released from leases, that's all they would have asking to be released from leases, that probably would have led to a different analysis than what actually transpired, where they just decided to wait and found out that it would really be significant numbers of people who were looking for those kind of releases. Okay. Response by the university to housing issues. At Student Legal Service, we developed a plan for continuing to serve with off-campus, to serve students with off-campus housing issues. And then that has resulted in an office that now works remotely, but is actually serving record numbers of students with housing issues right now. So that's not a total response, obviously, by the university. There were many, many things that the University of Minnesota did as an institution, but in the area of housing, in terms of off-campus housing, our office was certainly at the forefront of realizing we're going to need to deal with a lot of issues, even though many other things at the university were sort of put on hold, but that could not be the case for us. So that leads us to what really we've been seeing as the major COVID-19 student housing issues at our office, at Student Legal Service. I broke down cancellation of leases into two categories because it really is two sort of distinct issues. The first deals with cancellation of leases ending at the end of August. So those were the people who, for reasons, and there were many different reasons, but reasons relating to health or safety or just in some cases, I suppose, convenience, felt it was important for them to move away from campus as quickly as they could after the university shut down. But for many of these people, they had leases that ran through August of this year or into August, since many of them don't end at the end of August anymore. And so that created some real issues about what rents they were going to be paying, and whether landlords would negotiate or forgive any of those rents. And that was one very distinct group of people. Cancellations of leases for the upcoming school year is a whole nother issue, and that's what we're dealing with right now. A lot of students who are trying to figure out, can I cancel a lease because I don't need to be around campus? That would be more the issue for local students, but then there's this issue for international students. I can't get to the University of Minnesota, so I can't live there. And that's a whole another group of cases. It's led to a lot of subleasing issues. We'll talk more about that. Landlord and tenant communication issues. We've touched on that, but we'll go into a little bit more. Safety concerns, and then the last thing on that list is evictions. So evictions. Even in the university district, and we would not have expected much of this, and we haven't seen large numbers, but even in the university district, landlords have attempted unlawful evictions during the state of emergency eviction moratorium. And for most landlords who are confronted with the law, they quickly reverse course, and we have not had, for example, a need to have the Attorney General's office get involved. So I believe there was one actual eviction, and that that resulted in a person being temporarily housed elsewhere, but that person was leaving the country, so it didn't turn into a huge issue. At least one landlord's attorney has threatened to bring eviction actions against tenants who surrendered their units back to the landlord months ago. We've seen this very, very few times in our practice, but it's the kind of thing that gives you a lot of concern, because any landlord or landlord's attorney who's doing that is simply trying to destroy someone's rental history. They're not trying to get a unit back. The purpose of evictions is to determine who's entitled to possession. And if somebody has moved out of a unit and turned in keys, well, they've already decided they're not in possession anymore. The landlord's clearly in possession. So any attempt to evict under those circumstances is clearly improper. And really, they have to sign an affidavit when they file their eviction complaint, stating that the person that they are evicting is in possession of the property. I don't know how they were intending to do that. We've responded to that. We're hoping that that's not actually going to be an actual issue, but if it were, then I think that would be something that we would consider having the Attorney General take a look at as well.
It's not just the fact that they'd be committing perjury because the tenant isn't in possession, but they're also wasting their $300 filing fee. The landlord doesn't get anything they don't already have. As you just mentioned, they have possession already. That's all they could win.
That's right. And sometimes it causes you to wonder if maybe that's driven more by the attorney who is looking to pocket some extra money for doing that eviction action than it is by the landlords. But unfortunately, when you have another attorney involved, as we know as attorneys, we can't then just go to the tenant or to the landlord and say, oh, we can go to our tenant. We can't go to the other landlord and say, look, there's something really fishy here. We have to communicate through that attorney. But anyway, it's clear the law doesn't allow that. And so, again, we'll see that as it develops. We hope that it doesn't actually turn into an issue. All right. So the termination of issues of leases, ending in August of 2020. There are a lot of reasons why students need to terminate their leases, but most of them are sort of grouped around the idea that I can't be at campus anyway, or it's not going to be good for me to be at campus anyway. So if I don't need to be at the campus, I'm maybe taking my classes remotely. Why do I have to have this lease? And, you know, that's an understandable question from the standpoint of a tenant. Landlords on the flip side of that are, you know, looking at their situation and saying, well, we all are kind of in this together, and you signed this lease and I'm giving you the space. So you should stay and you should pay the rent. And if you don't come, you should still pay the rent. But there's a whole host of different reasons why students need to leave. International students are often compelled to leave the country. So what happened over the summer was extremely confusing to many international students. Some of them at the University of Minnesota, we have really a huge contingent of students from China. And students from China, many of them felt that they should leave when the COVID-19 caused the U.S. close. But then there were many others who left because the Trump administration issued an order saying that if campuses weren't going to open in the fall, that international students couldn't stay in the country. And so many of them thought, it's not likely to be open, I'm going to have to leave. That order subsequently got reversed, but not until, in the case of the University of Minnesota, thousands of students actually left to comply with the order. Students from other states have some of these exact same issues. We deal with students from Texas and California. They are a long way from home and they can't change plans on a dime. So if they're planning for the fall now that they know there's going to be problems with classes being held in buildings, they're more inclined to say, I can't come back to Minneapolis. And then locally, students need to stay socially distanced, and there's a whole range of sort of issues there. But a lot of students signed their leases at the University of Minnesota, signed their off-campus leases early in the process. And so it's not unusual for students to come to me that signed leases back in October and November of 2019 for this upcoming school year. There's a lot of reasons why they do that. Housing's been fairly tight around our U campus. That's not unique to the University of Minnesota. There are other campuses in the state that also have issues of adequate number of housing units. And so they sign early because they can get into the building they want and into a place where other people they know will be living. Unfortunately, if you signed your lease last fall, you didn't know anything about COVID-19. That really continued all the way until the first people who signed leases with any sense of what it really meant to deal with COVID-19 were later in March. And so that leaves us with hundreds and hundreds of leases that were signed before any of these issues were clear to anyone.
And Bill, I'm going to jump in. This really is a college approach for landlords. This is the only place we've seen. I don't know when you first saw an October lease signing for the following fall, but it's not been that many years that landlords have been doing that. But since it started, it's really entrenched in student-heavy areas where landlords, because it's very counterintuitive to people listening that don't know anything about the university areas or college areas, where somebody would sign a lease in October for the next August. So a lease that would start 11 months or 10 months later. And the reason why landlords are able to do it because the market is so tight and they want to lock people down. But it really is the only place we see this sort of thing happening in the state is in college, really specific areas.
Yeah, I think that's a great point. And you're right, Mike, this is something that has happened fairly recently. So 10 years ago, at the University of Minnesota, the Housing and Residential Life would work with other departments and set up housing fairs for landlords who wanted to make their pitch to students. And they would do that in late February or early March. And because of the way the buildup of buildings around campus, and because of the pressure that landlords put on students to sign leases early, that now takes place much, much earlier in the year. It's now typically going to be in October. Probably could even be earlier than that, but students don't even get settled in to the place that they are until, sometime in September. That leads to tons of issues in student housing. Most notably, for all of us who have gone to school and lived in a campus environment, if you're a freshman, for example, living in a dorm and thinking about signing a lease for next year, and they're putting pressure on you to sign an off-campus lease a month into your freshman year, you're probably going to sign that with your buddies. But if you and plan to live together in a sort of similar place, but if you look back to when you were in school, how many people, when they went to school and made friends their first 2 weeks of school, were still friends with all those people at the end of that first year? It really doesn't happen much. And so it creates these situations that are very, very, very difficult for student renters, because they'll end up with wanting to switch out tenants and wanting to switch from one place to another.
And we've gotten a couple comments on this exact issue. And one's, I guess they're really just comments, both of them, but one says, it's from Winona, that early rental issue extremely common in Winona. I thought it was unique to here. It's not. This happens in college areas all around the state. Our office deals with tenants all around the state. Bill's office focuses in the metro. But then we got, I assume this is something from a landlord named Brian. He says that landlords and tenants have contractual agreements and obligations to each other. Both sides have the right to rely on the lease. Landlords do lease signing in response to demand from students wanting to secure housing early. It's not accurate to say landlords have the ability to pressure students like you say. I've been renting to students for years and we've never pressured anyone. We respond to when students start calling us. So, I mean, and that's a landlord perspective, and it's a pretty valid perspective. And I'm guessing Brian has competitors too, and they're willing to sign tenants long in advance. So if the next landlord over is willing to sign a lease for the next academic year, if you want to compete with the other landlords, you have to make that same offer, because I'm sure he's right. Tenants are interested in that, right? That they want to sign up as soon as they can because they see that pressure. But to say that there's no pressure on students to sign the next fall, I mean, it just exists now. That's just what it is.
Well, I think that, I think that Brian's point is probably very valid in a number of areas and markets. And particularly, I think it's still valid to a certain extent around the Twin City campuses for smaller apartment buildings and smaller landlords, where they're not really so focused on making sure that they have X number of leases signed by a given date. Where we see this was brought to the University of Minnesota area by the huge national housing corporations. And they have large buildings with a big need to fill them, and they want to do that as early as they possibly can. And so to say that there is no pressure ignores the fact that there will be flyers distributed, some discounts offered, all kinds of things right away when students move in September. They'll start getting these things. And so it is driven in large part in those larger buildings by the landlord's needs and desires to get those buildings rented up as quickly as they possibly can.
And the housing is scarce, right? I mean, there's only so much. So there is competition for tenants to try to get this. But I think our main point about all this is this only happens in student areas. I can say that with a lot of authority. We talk to tenants all around the state, and I can remember 4 or 5 years ago, the first time I got one of these, and a tenant said they had to sign a lease for next fall. And I was, what are you talking about? Let me see it. And this is the only place we see it, and it is a recent phenomenon. This isn't how it's always been done.
Yeah. Yeah, and I think I'm looking at some of the comments, and again, Brian, who's the landlord who I think originally raised this, is making the point that that it results from lack of supply, not landlords' motives to take advantage. And I don't think that I've used the words or the concept to take advantage of students. I'm talking about pressure. And that pressure comes from the needs of these large corporations to fill their buildings. And it's true that there has been a really big shortage of housing in and around the University of Minnesota Twin Cities campus for the last 4 or 5 years. That's now easing a little bit because just the sheer numbers of units going online year after year after year is really starting to create a little bit of room in the market so that a student can actually wait and make a decision a little bit later on. But it's not a matter of simply someone taking advantage of another person. It's a matter of landlords having different priorities in terms of who they're accountable to. And, you know, big national corporation landlords are accountable to their shareholders, and they have to fill these buildings. And so they are not, it's not uncommon for them to go out early on in the fall and really recruit hard to get students to sign leases. I think they, you know, if there was some agreement by all the various landlords to wait and do that process later, like let's not anybody offer leases until sometime in December, I think they'd rent just as many units, but of course there would be a little less pressure on the students. There was some legislation proposed by Minnesota Student Association to try to create a window for students who move into large complexes so that they would not be compelled to respond to offers for lease renewals for a period of time. And it was discussed. I don't know how far it got. I remember seeing something about that. And of course, this last legislative session, most things just sort of disappeared when COVID hit. So I don't know whether that progressed at all. But so it's a real issue, and there are people looking for solutions, that's for sure. So we're talking about the termination of the leases ending in August of 2020. And I think we had pretty much covered it, the local students and their need to social distance. There really are some examples of cases that were really quite compelling early on when we were seeing students who wanted to get out of leases. And like just an example, I think a kind of a case that encapsulates how complicated this all is. There were a group of students living in a large apartment building. One of those students was a pharmacy student, and she worked 3 different medical related jobs and came into contact with COVID-19 patients every day. And she was living in an apartment with 3 other women. And the response to her situation from the 3 other women was, it's not safe for you to come here every day. And her response to that was, you're right, I really shouldn't be coming here every day. So we approached the landlord. This was a large corporate landlord. And we said, we really ought to work out an arrangement where we release this woman from this lease for the benefit of everybody in your building. And the response was, no, we're not releasing anybody. Now, that remains an active issue. It's still not resolved. I think it will still be resolved. But the woman had no choice. She had to move out for the protection of her roommates and for everyone else in her building. And so the issue now is how much rent would she appropriately owe for doing the right thing? And so again, that's an ongoing discussion. But it highlights, I mean, the landlord's correct in saying we still had the place available to her. She still could have lived there. She could have, but she couldn't have done it without putting a lot of other people at risk. This is the kind of issue I'm really worried about as we head into this school year, because we have a lot of questions and no answers, about what happens when a student who's exposed to COVID comes back to an apartment with several other people.
Well, let's go on to the next slide because I think we'll get to those topics a little more.
So the response that we got from landlords, most landlords were unwilling to release student tenants. That's been the case. That may change a little bit. Many discussions still going on there. Again, they did say they were valid because the space was still being provided. They expressed concern, but they put off decisions, and it's understandable if you look at it from the landlord's point of view. That's a very difficult decision to make, not knowing just how high this wave's going to be. But a lot of I put a few on here, but it's actually several landlords agreed to look at individual circumstances, and the ones that really agreed to do that and then followed through did end up releasing tenants, and many of those related to medical conditions, where students had verified medical conditions that put them at much higher risk than the average person for contracting COVID. And landlords in those circumstances have been pretty good overall about releasing tenants from their obligations on the lease so that they can be in a safer place. Tenant arguments for termination. So the inability of the landlord to provide safe housing during COVID-19 has come up. And again, this is all very subjective. So we have to look at all the circumstances in all those different cases. Some landlords find it easier than others to make appropriate arrangements, just because, in many instances, because of the design of their buildings. But other landlords find it very difficult to make accommodations just because their buildings don't allow for it. So it all, in many instances, boils down to who feels safe and what are the underlying circumstances. And so we've negotiated a lot of those cases. Like, as I said, some of those landlords, and particularly with health reasons in the play, have been willing to do releases of students from their leases. Due to breaches of leases due to loss of amenities. This is a tough one again. I mean, I think landlords really felt like, if we've got a swimming pool or we've got a computer room that we make available, a workout room, all of those things, we probably better close them because we don't want gathering places in the building. So I think there was landlords in those instances were making good faith efforts to comply with the governor's orders. But a lot of tenants would look at that and say, well, it's fine that you close those things down, but I'm paying a lot of rent. And one of the reasons that I agreed to pay the rent was because I would have these extra amenities. How about we talk about a reduction in the rent? I can't think of really any instances and cases that I've personally handled where those reductions have actually come into play yet. I suspect that they will, I think that they'll come into play at some point in time. Let me just see. Let's see. Yeah, there's a comment that these two from a landlord that these two things are the inability to provide safe housing and the breach of lease due to loss of amenities are in conflict with each other. I can see where, I guess from a landlord's perspective, you might see it that way. But I guess the issue here is who makes the financial sacrifice. And it's probably in the interest of a lot of people to negotiate a fair compromise on a lot of these issues. For a landlord to lay off half their staff, for example, because it's the right thing to do, but then for students to not have access to the services and the staff that they were accustomed to, and not have any reduction in rent means that that burden is not being shared equally. So,
and Bill, we have seen some landlords around the state that have given reductions. I'm not talking massive reductions. But if the amenities aren't included, they'll give the tenants $50 a month off, you know, a $1,500 a month rental. So it's not unheard of. It's not common. But
Yeah.
some landlords have said, you know what, we expect you to live up to this contract and we can't live up to all the parts of our contract, so we're going to give you a slight reduction. Plus, we don't have to do as much maintenance on, you know, the weight room and the pool room or whatever. So we've seen it, but it's not common that landlords just offer it up.
No, I'm not, again, we haven't seen a lot of it around, around the university, but I'm sure that some landlords are at least going to consider it now, because there will be some negotiation with landlords. Some students have withheld rent after they vacated, and landlords are going to want to negotiate to see if they can get some or all of that rent. And maybe some landlords would even choose to sue to get that rent back. But if they do, then they're going to face counterclaims for lack of amenities. So it just makes sense. Force majeure, you see this clause, the force majeure clause, you see it in some leases, and it's added by landlords in a lot of instances to protect themselves in circumstances where they might not be able to deliver a building, for example, that's supposed to open, might not be able to open on time because of some really unforeseen circumstance. So they put these clauses in the leases, and they typically don't think of using them very much from the tenant perspective. But the concept of force majeure does exist, and what it implies is that if there's an unforeseeable circumstance that prevents a party from fulfilling a contract, then the contract is not necessarily enforceable. And where this comes into play at our university and probably at a number of other colleges and universities, it comes into play in a big way for the international students who, through no fault of their own, are stuck out of the country. They simply cannot get here and can't live in the properties that they were anticipating. No one anticipated COVID-19 when they signed their leases. That would probably be different next year, you know, when people sign leases with knowledge of the pandemic. But nobody knew about the pandemic when the leases were signed for this year, at least for the majority of them. And so that's going to be a common defense, I think, offered up by tenants. And of course, there's not a lot of cases in landlord-tenant law where that principle has been tested. So it will be, I'm sure, and we'll know a lot more about it several months from now. And then the last thing, we see a lot of our deficiencies in the lease. We have landlords who, around the university, who either through lack of knowledge or because they want to argue that it doesn't apply to them, are not following one of the new statutes that requires them to specifically identify which unit they're renting to a particular tenant when the lease is signed. I think the next slide might be that.
Yep.
Yep, it's Minnesota Statute 504B11. And the law was changed back in May. And what the law now says is if in a building of 12 or more units, the landlord has to specifically identify, or the written lease has to specifically identify the unit that's going to be rented to a residential tenant before the lease is signed. And this was a huge issue in the large buildings around University of Minnesota campus, because landlords would routinely have students sign leases for properties without identifying any unit. And some of the large landlords,
I'm sorry, so they just say you get a one bedroom. We're not going to name the one. You don't get apartment 301. You just
Right.
get one of our one bedrooms.
one bedroom, one bath unit.
Right.
And so the problem became that many of the landlords would overbook a special type of unit. And so when the landlord overbooked a special type of unit, then students would go to move in and the landlords will say, well, I can't give you that 1 bedroom, 1 bath that I promised you, but I can put you in this 3 bedroom, 3 bath unit. And so they would be forcing people into these situations because rent was, or unit availability was tight, and the issue wasn't coming to a head until literally people went to move into buildings. And so it was a big issue. Then a couple of the landlords, in order to cut losses, decided to overbook their buildings. And so we ended up with students with literally no place to live, showing up to move into their properties and being told, oh yeah, I guess we didn't actually have a unit for you. So it didn't happen a lot, but it did happen. And if it happens once, it's too many times really, because you should be renting a specific unit.
And this is obviously a big building issue only. This isn't going to be a duplex.
It shouldn't be a duplex. It's got to be 12 units or more, obviously, in order for it to even apply. But it's coming up more in the big buildings. But around U of M campus, the big buildings are everywhere. And so this was becoming another big issue. The other issue that was really creating problems was that a lot of these big towers are built with bedrooms that have no windows. And so students don't know that when they're renting. They think that every bedroom has a window. But because of modern sprinkler systems and the fire codes not requiring windows in every bedroom, when they build the buildings, they don't put everyone in they don't make every bedroom have a window. That's a huge problem for international students who come 7,000 miles to go move into a room that they're literally going to be in every day until they have a chance to return home, because they don't have aunts and uncles to stay with or family nearby. And so they're going to be there every day, and they find out there's no window. That's been a big problem, and now hopefully will be lesser problem, because you've got to be able to rent a specific room, and the attributes of that room are something a person can actually check on. So the law was changed for a lot of reasons, but some landlords aren't following the law. They're just saying, okay, I'm still going to rent the way I always did because that was convenient. Now in the time of COVID, students are coming to us and they're saying, I want to get out of this lease. And we look at the lease and it doesn't identify a unit. And so our response is, there's not a valid lease here. We go to the landlords and we present that argument to them. Most of the landlords around the U have said, sorry about that, and are now adding the unit numbers when they sign the leases. But there's a couple of holdouts that I think will probably want to challenge that legislation in court, but they haven't yet, and it's the law. And right now, our position at Student Legal Service is it's not a valid lease if it didn't identify a unit when it was signed. And so that gives a lot of people an argument they otherwise wouldn't have, that a lease isn't valid.
I think we could probably skip the next slide. It kind of just covers what Bill did there, and go on to the international students, which you've touched on briefly.
Yeah. I think people, if you follow it in the news, you know a lot of international students just can't travel freely right now. There was recently a change where one of the things making it very, very difficult for international students was that they had to quarantine for 2 weeks in another country before they could enter the US. And they lifted that for some countries now, but still applies to China. And so students who want to travel from China have a very difficult time. There are very few flights going in and out of China right now. And they have to fly to a third country and quarantine for 2 weeks, and then try to make an arrangement in that country to fly to the United States, when most other countries also have extremely limited flights to the US, not all, but some. It's very difficult, and the cost is incredible. I mean, it costs as much to pay for those airline tickets as it does in many cases for the students to pay rent for a year. So it's really prohibitive for those students to travel, because the other issue is that if they get to the United States and they move into their accommodations here, they don't know if they're going to be able to stay in the United States. You know, it can be any order, executive order can require you to go. And that's happened now. So there's no current executive order that requires them to go, but that did happen earlier in the summer. So they can't be certain that there won't be another one. So there have been some landlords, and we've been happy to see this, that have agreed to terminate leases for international students who can get a letter from an appropriate university or government office verifying their situation. So there is an office at University of Minnesota, International Student Scholars Services, that will write letters verifying situations. And those letters, as long as they're accepted, the process goes pretty smoothly. If a landlord wants more, some of the landlords want government documents, and that's very difficult, because what happened in China was when travel bans went into place, United States closed large numbers of consulates. So there are many, many areas of China that do not have access to U.S. consular services right now, at least not easy access. You have to wait months and months for any kind of service. And so they just can't get a letter saying this person doesn't have a valid visa. Some people,
realistically, Bill, landlords are going to have a lot harder time collecting against international students. And if they're going to try to hold them to that lease, it's a consideration. I think most landlords, if they're saying, oh, can I sue them later if they walk out on the lease,
yeah,
it might be hard to collect, right?
it's going to be extremely hard to collect. It's very difficult to collect against students as a whole, just because they're so mobile, and it's very hard to kind of keep tabs on them. But we have, in our marketplace around the university, have seen landlords, in recognition of this fact, apply different standard in their security deposits, for example, to students, and they charge 2 months of rent in advance. It's because they think, well, the student may have to leave the country. And so they have, in many instances, they have that money, and now what they collected it for has happened. The students had to leave the country. So in those instances, you think it would be fairly simple to say, okay, let's cancel out the lease. And it may be in some of them. Again, most of the landlords are still waiting to make their waiting to make their decisions about how they're going to handle all those. But the trend now is towards releasing the international students, because it doesn't necessarily cost them anything. You're right, it's so hard to collect. There's a question about if I can cite the executive order that required foreign students to leave the country. Actually, I think I misstated that. It was prohibited foreign students from returning to the country unless universities could guarantee that they were offering in classroom.
Yeah, we're talking about the
yeah.
2020-21 year now, right? That's what we're talking about. Yeah, the returning, yes.
Forward, but there was a question about
Yep.
that executive order, and it's true. I stated that backwards. The order actually kept people out, didn't require people who were here to leave. Okay, and then the other thing is, all right.
Should we go on to American students here?
Yeah, let's go on to.
Okay.
All right. For U.S. students, there's still a lot of students who are going to need to terminate leases. And again, I already talked about that. One of the essential problems being that the leases were signed a long, long time ago, months and months ago, before COVID was even an issue. So We've successfully worked with landlords to release a fair number of students with medical conditions. That seems to be one thing that we can all agree on, is that people shouldn't have to risk, you know, everyone in a sense might feel they're taking a risk, but certain people are really able to document that risk because of the medical professionals that they deal with. So those students, when they're able to document it, um, landlords have been willing to allow those students to break leases. And we've had some landlords who are willing, upon showing of economic hardship, to either renegotiate or to release people from leases. That's come up in circumstances where family hardship, you know, you have a lot of the landlords will ask for guarantors, and the guarantors are typically the parents. But we've had families where both parents have lost jobs during COVID-19, and the student is not able to work in the summer either this summer because jobs are scarce. And based on that, they're making different decisions about what they're going to do. Most of them are saying, well, I probably better pay my mortgage with the money I've saved than try to pay rent near campus. And the landlords have been good about that, and recognizing that those circumstances have changed and have put a lot of people in an economic bind. And there have been some instances where landlords have worked with tenants to decrease overall rents, to just as a way to say to the tenant, I'm trying to help you, but I want you to help me a little bit too by making sure I don't have an empty space here. And it seems like all the landlords that we're dealing with are encouraging subletting with varying degrees of cooperation. So that last little caveat is there because some landlords are waiving all of the fees that would ever be associated with subletting in their lease. And some are actively looking for other tenants for their student renters. And some are basically saying, we usually don't allow any subletting, but we won't stand in your way. If you find somebody and sort of hand deliver them, we'll work with you to do the paperwork. So it's a whole continuum, but I think everybody knows that in these times, it's important, if possible, to have the renters in the building, and the landlords want that. The tenants are well served if they can find somebody to take their place. And one of the things that I was really very surprised by early in the spring was when everybody was sort of leaving the campus area. I talked to some landlords who said, we're really doing a lot of subleases, and I couldn't figure it out. And then I realized it was the people from the dorms going into the neighborhoods that were taking these sublets. And so there was actually some shifting going on, but subletting wasn't impossible. It was just taking place in a way that we really hadn't seen before. So force majeure, we talked about that a little bit.
Bill, we haven't really seen cases answering the question about force majeure on this pandemic, right? Because, well, courts are closed.
Right.
I mean, they just are. If you want to go file a claim as a landlord against a tenant for unpaid rent, not an eviction, but a claim for unpaid rent, and the tenant wants to assert a force majeure defense, we can't say what the precedent is for COVID-19 in the year 2020 because those cases either aren't filed or they're not being scheduled yet. So we don't know what the result will be.
Right. And with force majeure, the real unclear component always is this a big enough disaster? And so you almost would think with a pandemic, it has to be in some sense because it's just unprecedented, but you don't know what the courts will say. So it's an issue to be determined. I think we talked about 504B 111 in quite a bit of detail before, including the position that our office takes. So I don't think we need to spend any more time on that one.
Okay.
The subleasing issues, again, waiving the sublet fees is big because it really motivates the tenants to get out there and find people knowing that they're not going to have to pay a lot of extra money. And when you're talking about that, the subletting fees and leases are really across a wide continuum, and some of them require you to pay a fairly large sum of money and then an additional month or two of rent, and then they'll allow you to sublet. Um, so if those kind of things can be worked through, and the tenant can see that it makes sense to sublet, it also helps the tenant a lot, because one really good motivator in the sublet market is if a tenant can, it's not unusual for a tenant in the university district to pay a rent of around $800 or $850 a month. If that's what they're paying under the lease, and the landlord waives sublet fees, then there's a good chance that they can go market that unit to someone else for $700 a month. And that's going to increase the pool of people who can afford to rent there. And it's going to make that property stand out amongst others in the marketplace. So that's been a big thing. And many landlords have been willing to do that. And we've made it clear to landlords that, these are unprecedented times. And so we know a lot of landlords are generally willing to work with their tenants to sublease, but we know some that over the years have taken a pretty solid position that they don't want to. We've made it clear that we really think they need to in these circumstances, and so far, most of them who used to be reluctant have said, I can see that, and again, it works in their favor too, because one thing that I've experienced over the years, landlords love to have tenants in their building paying their rent. And that's so much easier than the prospect of potentially bringing a claim in court to try to collect rent from someone who couldn't pay for several months.
The last line you have there, that landlords might be considered uncooperative, is that some sort of, is there some ranking somewhere that you guys have, or what does that mean?
That's pretty unique to the University of Minnesota. At the University of Minnesota, the regents have a policy that landlords can only have 3, within a calendar, or not a calendar year, within a 12-month period, landlords can only have 3 unresolved issues with student legal service. So what that means is landlords can be, excuse me, Scott's saying it's not a regent's policy, but it was actually presented to the regents at one point. Let's see here. I missed Scott's message. So maybe it's not actually a regent's policy, but I know that the regents had to review it. But anyway, there's a policy, and housing and res life, student legal service, and off-campus living evaluate landlords who have attained the level of 3 unresolved cases with student legal service. And to get an unresolved case, the landlord general has to have 3 cases in which they simply didn't cooperate, or cases where they, let's see. Okay, it's just a housing and student affairs policy. Scott Career has corrected me, and I noted that. Sorry for that misstatement. I just recall a process a long time ago. So anyway, they can have up to 3. Then if they are reported as having 3 or more, then it goes for review by off-campus living. They will contact the landlord and they will talk to them about whether they want to work to resolve the issues. And if they don't, then they go on a list of landlords who are considered to be not in compliance with university policy. And it's a public list. Right now, I believe there's probably only 5 landlords on that list. And it's published through Off-Campus Living's website. And a landlord who goes on the list has to stay on the list for a full year. And then after that, they can apply to come off of the list. But during that year, they cannot participate in university activities. So they're not allowed to they're not allowed to take part in housing fairs, which is a huge issue for landlords in the university district. and they're not allowed to list through the off-campus listing service that is supported by Housing and Res Life. So that's a big deal to most landlords. And so
And some other colleges have similar types of lists. I'm not sure that it's the exact same format that what you use,
Yeah.
but other places do. Let's get to our last two slides and get to some questions though, after that, if we could.
okay, negotiating out of a lease. Now, we don't see many leases at all that have buyout provisions. And then we do see occasionally a lease like that. That's usually going to be more with the landlords who are renting the smaller units in and around campus. But if there are buyout provisions in the lease, that's something that is really important in this time to look for and to negotiate with the landlord. And I wish we'd see more of it. And I'm wondering if, as a result of COVID-19 and these considerations, we might not see more of it in the future, because right now it creates a lot of uncertainty for both landlords and tenants. And if there were buyout provisions clearly stated in the lease, and I think it would be clear to everybody what expectations might be. And then the landlord may be willing to take something instead of nothing, which is what they may be stuck offering. That's really the case with a lot of the cases, but as we discussed, particularly true with a lot of the international housing issues, student housing issues, is that for a landlord to sort of hang in there with the idea that they may be able to collect that entire lease, even though nobody lived there all year, it's a pretty big risk when you're talking about that with students who may not come back to the U.S. So communication issues, we talked about that cutback in staffing, and I was surprised really by how much that affected communication with tenants and their landlords over the COVID period. We heard from lots of students who simply couldn't get answers to questions. And I think a lot of the landlords now have made pretty good adjustments, and that this no longer is quite as big an issue, but it has been a problem. And if we did have a serious COVID outbreak again, I think it could be an issue again. Some landlords have taken decision-making authority away from local management. That really has an impact on an office like ours, where we really do develop relationships with local management personnel in these larger companies, and have worked out lots and lots of issues just with a phone call. That's pretty hard to do now that a lot of the local decision-making is not there. And then some landlords immediately turn to their attorney when we get involved. That can create some problems too. Obviously, any landlord who hears from us and wants to work with us through an attorney has the right to do that. But then the biggest problem is that the landlords still want to communicate directly with us, and we can't do that. We have to go back to their attorney. We're bound by our ethical rules to do that. So I don't think landlords usually fully appreciate that's the situation they're creating. Okay, safety concerns. So the concerns within the apartment, we talked about that a little bit, that one example that we spoke about, and in common areas of the buildings. Again, I think a lot of landlords have worked pretty hard over the last few months to sort of figure out how to make their buildings safer and things they can do to lessen the impact of COVID within their own buildings. But as we talked about, for some, it's pretty close to impossible just because of the way their buildings are set up. It is a problem with the staff cutbacks, and that's where we heard a lot about safety concerns, where people are saying, I don't like going into the building at night now. It just doesn't feel right. It's just, if people are social distancing, that's probably how it's supposed to work, right? There shouldn't be people in the hallways, and there shouldn't be a lot of interaction. And so that can make people feel less safe. And then within the broader university district, I've heard comments from students about the overall lack of foot traffic, making students feel less safe in areas around their buildings. And that's certainly true. If you're going to run out to get a cup of coffee or a sandwich or or something from your building and return and it's later in the evening, it doesn't feel as safe because usually there's hustle and bustle, and that makes everyone feel a little bit better. But right now you don't have that. So
Sure.
uh,
Well, Bill, I think that's through the material you'd prepared. We have about 15 minutes to go. I should ask to start. Can you drift over 10 minutes, or do you have a hard 3 o'clock break?
no, I can drift over if they.
Okay. Well, what I'm going to do is I'm going to take the pre-submitted questions and the ones that are really college specific first.
Okay.
And we'll go with those. And Brian, who's been communicating with us through the chat box throughout this speech, had actually submitted in advance a question about the money. And so, Eric, you might have more of a thought on this than I know I do, which is, are students eligible for that $100 million housing assistance program allocation, or would they not be eligible? Do we know?
I did put a link in the chat, and I'll do it again, that has the information from Minnesota Housing about eligibility. The key points are you have to be a Minnesota resident, a renter, or a homeowner at income at or below 300% of federal poverty guidelines, have an eligible expense from March 1 that's past due. So anytime rent that's due from March through December of this year, and then be unable to make the payment because of the public health emergency due to unemployment, illness, COVID-19 related issue. And then following up on something that somebody did put in the chat, if you receive rental assistance already, like Section 8 voucher, then generally you're not eligible to apply. But if you have questions about it, it's probably best to just go to that website or contact them to get information about how to apply and if you're eligible. And I think if you're a student and you fit that criteria, I would assume you'd be eligible.
Okay, got a question from Amy, who self-identifies as being from St. Thomas. How realistic is it for landlords to do COVID-related addenda in leases that began June 1, 2020? I'm not sure how to answer this one because I don't know exactly what these addenda might look like, but I'll let you have a go at it, Bill.
Well, it's not very realistic at all, and we're seeing landlords who are trying to add some addenda now to leases. Basically, what they are is sort of waiver of responsibility for COVID. And
oh, that's what she means. Okay.
And so I don't think landlords can effectively actually add those addenda to leases, but some are trying. And we just had one major landlord in the university district back off because they had gotten enough resistance from the students who are all saying, we're not signing this. So, there's no reason why you have to sign an addenda that strictly addresses the issue of COVID from the standpoint of relieving the landlord of any responsibility for outbreaks in the building.
Well, on a real basic level, the landlord's trying to change the contract once it's been signed and agreed to, right? And you're just saying, well, you can't.
Right.
Yeah. Okay.
And it's not a bargain for kind of thing. It's
sure.
Just another kind of waiver of responsibility that a landlord, and not very many landlords are doing that, but that a landlord might try to put in there. So,
Michael from St. Thomas, some of these questions are going to seem duplicative based on what we've already talked about, but this is what people care about, so that's fine to just re-summarize it. His question is, if my classes go online, can I amend my lease? Is that enough to trigger some sort of I get to amend my lease rule?
Well, the actual answer under the law is that nothing in the law is going to say that your landlord has to amend that lease because St. Thomas changed its policy. But as a practical matter, your landlord may be willing to discuss that with you. And that's also the area where potentially looking for a sublessee can come into play, because if you're feeling like I don't want to be near campus, but you can find someone who actually is looking for housing near campus for other reasons, then you want to work with the landlord to see if you can get a sublease. But you can always negotiate with your landlord, at least attempt to negotiate with them. Not every landlord is going to be open to that, but if it's going to be a situation where you feel like the property is going to be less valuable to you, it doesn't hurt to talk to your landlord. And again, there's all kinds of factors that go into that. For example, if you're a tenant who's been living there for 3 years and all of a sudden you feel like you need to be away from campus for a while because of COVID-19, your landlord's probably going to look at that and say, well, you know what, this guy's been a great tenant, and I'm going to work with them. But you know, in other instances, they maybe don't really know you, and in those circumstances, they're probably less likely to want to work with you on that. But you certainly can always raise it, and any good landlord's going to let you know they don't mind that you raised it, but they'll also let you know whether they feel they can do anything for you.
Heading over to McAllister, Liz asks, how different are renters' rights laws in different states? Are there federal laws or are they all state laws?
Well, in landlord-tenant law, pretty much everything is governed by state law. And because University Student Legal Services at the University of Minnesota, we're part of a group that of students attorneys around the country. There's 360 different universities and colleges that have student legal services, and so with the with that being the case, we compare our state laws a lot. I noticed, I think you said that you were from Illinois.
Yeah, they asked about Illinois. Yeah.
Yeah. So I don't know much about Illinois law in particular, but in Minnesota, when we go to the conferences and we compare the laws, I would say there's only one state that we, as tenants advocates, envy a little bit, and that's Massachusetts. They have probably the most tenant-oriented laws in the country, but otherwise, people look at our law and say, "Gee, we wish we had that." So our law is pretty good in most instances,
There's also city rules, though, Bill, which are now starting to rise up. You mentioned security deposits being giant for some international students in Minneapolis. There's now limits on security deposits in some buildings.
yes, yeah,
And
those just came into play
Right.
this year. So security deposits are limited, and that there are protections in the local in some city ordinances. Minneapolis and St. Paul both offer
Right.
some particular protections, but
On the federal level, one of the people chimed in on the chat box saying, aren't there fair housing laws? Yes, there are. That's the one federal part of the law that really has an impact in landlord-tenant law generally, is fair housing, discrimination, Americans with Disabilities Act. But you're right, it's almost all state law specific. That's sort of the starting point for most of these questions. Staying at McAllister, Zara, I think, asked, can landlords legally restrict who is allowed in and out of your building if it wasn't a part of the original lease you signed? Now, this is certainly something I could see a landlord proposing with COVID-19 concerns. What do you think? Can a landlord change that rule if the lease is already in place?
well, I mean, it is an interesting question, because ordinarily it would be very difficult for a landlord to restrict who comes in and out of the building if there were no restrictions in advance of signing the lease. But in the time of COVID, there might be some actual good reasons why a landlord would want to put some restrictions on entries into the building for the protection of everybody in the building. And so that's a really tough one to analyze without knowing exactly what restrictions are being imposed and for what purpose. And
There were points when the governor's orders might have precluded it earlier this year as well. So a landlord could have been simply helping to enforce the governor's order. I guess they could at least call the police, I think have been one of the ways to try to enforce that at that point. But that is a tricky question, I agree. Karen from McAllister asks, can COVID-19 high-risk people break the lease? Does that give them an extra bit of leverage legally to get out of their lease?
well, what we found is, again, there's not going to be anything specific to COVID-19 in your lease unless it was just signed very recently and contains some specific language. But what we found is that's the one category of tenants that landlords have been generally willing to negotiate with to terminate leases. So if you're in a high risk class and the building itself presents some issues for you, then I think you should have a good conversation with your landlord. And a lot of them, it doesn't benefit a landlord at all to have someone bring COVID into the building. So if your high risk
Right.
comes from your circumstances of your job or something like that, then landlords are going to generally be open to negotiating perhaps lease terminations or limitations. But it's a great question, and I think that if you are in that class of people, that you're probably one of those people that's going to be finding your landlord pretty open to discussing changes in the lease.
Same person asking a follow-up question. How can rent get lowered if public amenities and buildings are closed for COVID? I think she's asking for negotiation tips here.
Yeah,
guessing.
well, I mean, it all falls into the general concept of rent abatement. And rent abatement is just a claim that some of the rent I paid shouldn't have been due because I didn't get everything that I was expecting. You don't often see it around amenities, although it's come up from time to time. But what you're more often going to see is a situation where a portion of an apartment becomes unlivable, maybe due to flooding. A basement area that people were relying on using gets flooded, you can't use it anymore. Now you want some of your rent back. But that same law does apply to amenities, and the same concepts apply. So what you're really talking about is the whole concept of rent abatement and the ability to say, this isn't exactly what I bargained for, I would like my rent to be lower.
And Eric, if you could put up the next slide, just so we could show people again next week's show with Catherine Keller from the Attorney General's office. Again, the Attorney General's office has an outsized role in landlord-tenant law right now because they are the only agency that enforces the government or the governor's order barring evictions. So we're going to be hearing from her next week, the first time we've had her on, and very excited to hear what they've been working on. But we're going to finish up with some last questions, and we're going to stick around a little longer because we do have a lot of questions, and I'm going to do all the student-specific ones today. From Jacqueline at St. Thomas, can the university get involved if they think I'm not obeying the social distancing policies in my off-campus living situation? We've heard about this in the media, campuses all around the country.
Yep, and that is largely going to be dependent on the type of rules that your college or university has governing circumstances off campus. At the University of Minnesota, we actually have a student conduct code that goes off campus with the students. So that's been in place for many years now, and it's not unusual for students to face disciplinary hearings for things that have happened off campus because the code goes with you. Now, other universities and colleges might not be as specific, but if you look at the St. Thomas website, you'll see that they have basically listed expectations for the time of COVID, and that includes a lot of things around large social gatherings and things like that. Whether a university would actually use their disciplinary process to go after a student who they felt had violated that is not clear, but we did see with St. Olaf, that was all over the news, where the St. Olaf administration decided they were going to discipline, I think it was 19 students for having an off-campus party that took no social distancing at all into consideration. So my guess is that you could find yourself dealing with administrative review at St. Thomas as well.
So this is not really a state law answer. It's look at your school's policy. That's what really is going to be the driving force here, probably. Okay. Catherine from Our Saviors asks, are there any additional things to note when talking about college students who are on a housing support program?
This I'm not certain what we're talking about with housing support.
Yeah, I can't say that I know either specifically. It's kind of a broad definition there.
It's what I think it used to be called GRH. They call it housing supports now, group residential housing.
Oh, I really don't. I'm not well versed in GRH, so I'm not really sure if I could offer much in that area. Perhaps Homeline's dealt with that more.
Eric, I don't live in this world either. It's mostly private market landlord tenant stuff that I do. Do you know much about the answer to that one, or where they could at least look that up for some information?
I mean, I guess it would depend on the individual circumstances, but again, I guess, if you have a housing support program and you're already housed, you're probably in a good spot because your rent is going to be close to guaranteed, like a Section 8 voucher. And so if it's about trying to find a landlord with a voucher, I mean, I think we talked about this in previous webinars that right now, somebody with a voucher or a subsidized housing program may have a better time than in the past when vacancies were much tighter to find a place because those programs are generally guaranteed rent as opposed to a situation where tenants may have trouble, maybe having financial troubles and may not be able to pay the rent.
Okay, this one isn't specifically college specific, but I think it really does apply. Michael, a landlord, are tenants who will not implement COVID restrictions in the common areas of an apartment building be violating executive orders? And then he names a couple of numbers, 81 and 79. One of those is about the eviction limitation. The other is about mask requirements. So we had an earlier question, what will a college or university do as far as enforcement against students? This is a landlord asking, what can I do if the students won't obey the mask requirements in the hallway or the lobby?
I suspect this is a question that I will end up dealing with quite a bit over the next few weeks, but one that I really haven't dealt with. I do think that a lot of landlords are going to feel like it's going to be a problem for them if their tenants are gathering in such a way that it puts large numbers of people in the building at risk. I do think that you can call attention to it by, if you know the specific individuals, by saying, I'm aware that you've had this gathering and it was not held in compliance with the governor's restrictions, and I expect you to follow the governor's restrictions. Could you ultimately file an eviction action? I think if you documented it carefully enough and somebody had multiple instances, then I think that you could. I mean, most leases say you have to comply with state and local ordinances and laws. And I think the executive action of the governor would certainly fit within that realm. So there is an avenue for you, but you're going to need to serve notice or send notice to the tenants and document your case if you're going to want to be successful.
Right, under the governor's order, the standard I think the landlord has to get to is that that tenant, who for instance isn't wearing a mask in the hallway, is seriously endangering the safety of others. I think they have to get to that level in order to be able to evict for this, which is different than the mask violation standard. But for an eviction, it's a lot harder, I think. The call that we've gotten, by the way, on the hotline is landlords' employees not wearing masks still when they go into rental units.
Yeah.
And we are sending those cases to the Attorney General's office, and they deal with them. Here's a different question. What should on-campus college students do if they move in and are then asked to leave due to a COVID-19 outbreak?
So that's an on-campus situation, which means that housing is probably being provided by the college or university. Mm-hmm. And I think that, again, is going to be different from school to school. University of Minnesota just had a pronouncement about that where they were saying that they would, again, make housing available to people who couldn't get it anywhere else during those times. So I think one of the most important things that students need to do if you're in that situation and you need to be in that housing for some reason, that you need to communicate with your university or your college to let them know, I don't have another option. I want to work with you to find a place here on this campus where I can safely house for the next however many weeks or months.
What if this were off campus, Bill? So same question. What should off-campus college students do if they move in and then are asked to leave due to a COVID-19 outbreak by their landlord?
Well, then you have to negotiate with the landlord, because if the landlord is basically saying, I want to empty my building out of concern for COVID-19, you could go along with it, but then you would want to make sure that there was a written agreement to terminate lease and obligations and then move out. It's hard to imagine a situation where a landlord would really want to do that, but that could come up. And I would think it might come up in smaller buildings. It could come up, like an example I can think of is maybe a person with maybe an elderly parent is renting out a room or two in the upstairs of their house, and they're concerned that one of the people who's been living up there has COVID, and then now they're concerned about the health of this elderly person who's also in the house. That might be an instance where they would say, well, we want everybody who's not actually part of our family to move out. But again, that would be a negotiated move out because you have a contract to be there.